Okay.
Good evening. It's 13 minutes past 7 on June 9th, and the Zoning Board of Appeals meeting will come to order.
Pledge allegiance.
First thing is the Pledge of Allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, roll call.
John Glenn.
John Julian.
George Slingo.
Roger Dubois.
Brian Canty.
William LePage.
Okay, want to make a motion to appoint?
No, we don't need to. We got 5.
Okay,
We've got the whole board here.
sounds good. All right. Mr. Brackett, can you please tell us what you came up from the last meeting?
Mr. Chairman, I just want to report back to the board regarding the issue that was discussed at the last meeting, and to provide you with my legal opinion on the status of the applicant. As you know, the property in question is under Chapter 61A of the Mass General Laws, which is agricultural land which receives a tax benefit, and that the statute and the legislative intent is for the protection of agricultural land in the Commonwealth. Pursuant to Section 14 of the statute, if a property owner who is under 61A wishes to change the use of the property from agricultural to non-agricultural, or to sell the property for a purpose that's non-agricultural, that individual is required to give notice of intent to sell to the Board of Selectmen, and the Selectmen then have 120 days within which to exercise a right of first refusal. Now, this is an issue which has been in the background of this case, and we did, I may have mentioned to you at the last meeting, I provided you with copies of correspondence that Mr. Balakonis, the town administrator, sent to the owner, Ms. Moninsky, on May 16th, advising her of her responsibility under the statute and the fact that she had not yet satisfied that responsibility. I also have had correspondence with Attorney Tallerman advising him that in our position, the property is subject to 61A, the town has a right of first refusal on the property, and that the interest of his client, the Islamic Society, is secondary to the interest of the town. As you know, the town meeting considered an article that was presented by the selectmen to authorize the selectmen to exercise their right under 61A, or right of first refusal, and actually was even broader than that. It actually authorized the selectmen to acquire the land by purchase, gift, or eminent domain. Since that time, I have spoken with Ms. Moninsky by phone, following up on the letter that Mr. Balakonis sent to her. I've explained to her that we're waiting the notice of intent to be presented to the Board of Selectmen so the Selectmen can make a decision. She indicated that there was some misunderstanding on her part early on, but that she had requested Attorney Tom Brusso to take care of preparing the notice of intent, and that he was on vacation this week and would be expected back next Monday. I called Attorney Brusso's office, left a message with his secretary, specifically inquiring about the notice of intent, asking him to call me when he gets back, and I also sent him a letter. I sent a copy to Mr. Balakonis. I sent him a letter on Tuesday confirming that I was requesting him to contact me as to when we can expect to get the notice of intent. So we're essentially working on somewhat parallel tracks here, Mr. Chairman and members of the board, with the fact that we've had this zoning application filed on January 7th, but in which the property owner, Ms. Moninsky, apparently signed a purchase and sale agreement with the Islamic Society, but she did not provide the required notice to the Board of Selectmen. And that's a responsibility certainly of the owner and her attorney, And I would suggest it's a responsibility of the Islamic Society and its attorney, since they're buying land that was clearly in agricultural use. And the status of 61A properties is pretty common in the Commonwealth. The protections and the procedure are well known to all attorneys who are practicing municipal law. The fact that that wasn't done is we're sort of having to catch up with that process while we have the matter before you tonight. Technically, in my opinion, the Islamic Society does not have the proper legal standing at this point because their interest in the property is clouded by the notice of intent requirement and the action by the Board of Selectmen. If the notice of intent is submitted next week, the Selectmen choose to exercise the right of first refusal. It would then go to probably a special town meeting for a 2/3 vote to appropriate the funds, and was proposed in the article at the annual town meeting warrant that there would also be a ballot question which would have to pass by majority vote to allow for a debt exclusion. So there are three separate approval levels on the part of the town once that notice of first refusal is received. And the sooner we get that notice, the sooner we can take the steps necessary to determine if the selectmen are going to exercise it, and if so, what town meeting and the voters of the town will do. So, Mr. Chairman, that represents the concern with respect to 61A. For the benefit of the discussion tonight, your options with respect to this special permit application, I would suggest are three that I can think of. One, you can approve it as it was requested without conditions. You can deny it, or you can approve it with conditions. And the denial could be, in my opinion, based upon a lack of standing because of the 61A matter, and I've prepared a 2-page motion to that effect. If the board decides that what it wants to do is to consider that option while you discuss the merits of the application, one option would be to approve the request for the cemetery with conditions. And those conditions could relate to the density of the cemetery, the size of the cemetery. As one example, I had a case a couple of years ago where an applicant made a request for a 640-unit project on a parcel of land in the city of Woburn, and the zoning board decided to approve it at 300 units. Cut the size by more than 50%, and that decision was affirmed by the reviewing courts. So you have the authority, after you've heard all the information from the neighbors, from the department heads, from the town officials, the authority to make a decision as to whether to approve it as requested or approve it with conditions, including modification of the size. And I'll just finish on one point, Mr. Chairman. I know there was some discussion about the, at last week's meeting, about a plan that had been circulated from the applicant's engineer proposing a smaller scale cemetery. I have explained to opposing counsel, and I've talked to Mr. Balakonis about this, that in my opinion, in order for the board to receive an amended plan at this point in the process, you would have to reopen the public hearing. And that way you would have to give notice to the abutters of the fact that the plan they came and spoke on in February and March and April is now a different plan, and they have the opportunity to come and speak on this different plan or not attend. But you do have to provide them with that notice. If the amended plan had been presented during the public hearing, before we closed the public hearing, then you could very much legally consider that amended plan reduced in scope as part of your final decision. So I know that there was some suggestion last week to the applicant about whether or not they were willing to extend the time frame to consider the smaller plan, and the applicant indicated at that time that they wanted to proceed with the original plan. I don't know if there's been any change in their position tonight, and I'll certainly, Mr. Chairman, I defer to you to contact them about that.
I have not heard anything. I believe You're still going with the plan that, as presented, correct?
Can I address the chairman?
Yeah.
Thank you. Mr. Chairman, a couple of things. I'm not an attorney, clearly, so I can't discuss legal issues. But it's our understanding that the 61A issue has no bearing factor for this board. This board is to vote on our application for cemetery. Let's say that someone came from outside and declared something, and I think this board has no really reasons to be disturbed about the land. We will deal with these issues with the owner, with the attorneys, with everyone. So we have no. Regarding what happened last time, I don't know if it will help if I give you some background or it doesn't help, so it's up to you, Mr. Chairman, if you want me to give you some background about the plan that was distributed last time.
No.
It doesn't help. Okay,
Doesn't
so-
matter. We're not going to consider
So
it.
our request now is for you to vote on the current existing plan as it is right now.
Right.
What we have committed to the media and to the public and to the town of Dudley and to the people that we will limit our use. Even if you grant us today the whole thing, we were going to limit to about 5 acres. That's our commitment to the town. That's on a voluntary basis. That has no bearing factor on you. But that we wanted to say that to make it part of the minutes of this meeting, that this is our commitment. Thank you, Mr. Chairman.
One more thing.
For the record, my name is Imad Surain. Again, just to follow up on Dr. Bahnasi, regarding the 61A issue, we know this is the town's right.
Mr. Slingo, could they identify themselves, please?
He did.
We didn't hear it.
Oh,
My name is Imad Zurain from Develop Zurain.
Thank you.
I'm the civil engineer for the proponent. Regarding the 61A issue, the applicant understands it's the town's right that has the first right of refusal, and they're not challenging that right. And it's just a matter of going through the channels. We're before you to get the approvals. If that happens, once the notice is submitted to selectmen, and it goes through the motion. But we have to start somewhere. That's why we're before you, to see if we could get the approvals. I just want to make sure you understand that the 61A, we're not fighting the 61A issue. It is a right that the town has,
right.
and if they choose to take it, we'll walk away from it. That's
Okay. Thank you.
Mr. Chairman, I have a question through you to Town Council, if you don't mind. So if the zoning board were to grant an approval, could it be subject to all rights and reservations under Chapter 16(1)A?
Yes, I believe it could, Mr. Chairman.
So the town would still retain its rights under that, and could include that in any motion, if there were a motion to approve the project?
Yes, Mr. Chairman, that would clearly make it clear that the contingency for the applicant is that only upon such conditions as to whether the selectmen either refuse to approve the right of first refusal, or town meeting or the voters reject the question, would the rights under the special permit be exercisable.
So if the town at a full meeting voted to buy the property, our vote would be null and void. If we voted to approve it with conditions or approve it the whole thing.
Right, if the selectmen, town meeting, and the voters, if it goes to the voters as a debt exclusion, if the voters approve it as well, then the special permit rights would essentially be void.
Mr. Chairman, but suppose instead of operating that way, we decided to deny for lack of standing. In that instance, the same procedure would have to take place. The town meeting would have to vote on it, and then it would have to go for a town vote. And if the town decided not to buy it, they would be, at that point, they would be able to come back to us and seek a special permit.
Yes, that's correct, because the decision to deny would not have been on the merits of the proposal. It would have been on the question of their legal standing before the board.
I'd like to make a motion that the special permit we're not denying the special permit. I'm denying the applicant's ability to request a special permit because they have no standing. They're not a property owner, and they're parties to a contract that we have the town has a superseding interest in. So that we only listen to people who have title to the property or prospective title. And they're on notice that their prospective title is subject to the town's superseding interest.
That's right, Mr. Chairman.
So therefore, they are not an appropriate applicant.
I would agree with that, and if the board were to consider denying, it would actually be a denial of the application for special permit. The reason is for lack of standing, and as I indicated, I had prepared a motion to that effect for the board's consideration.
Would they still be allowed to come back? As I recall, if you're denied a special permit, you can't come back for 2 years. That wouldn't apply to this, in this case, though.
No, because the argument would be that, and we could certainly incorporate that within our decision, that because it's not a decision on the merits of the application, where if you're going to come back within 2 years, you have to make substantial and material changes. We're not making a decision on that basis. We're making a decision on the basis of this information that we have relating to the status of the applicant and what's expected to take place regarding the property.
Mr. Chairman?
Was there a question?
Yes, I have.
Please.
Thank you, Mr. Chairman.
Could you please state your name again, please?
My name is Amjad Banasi. I'm representing the Board of Trustees of the Islamic Society of Greater Worcester. Again, I'm not an attorney, and unfortunately, an attorney is not here today. But just answering the gentleman's point of view, everyone applies to the zoning board before they get whole possession of the land. All people do that. If people are going to wait to get the possession of the land, then there will be. So you know that very well, that everyone applies, number one. Number two, if that was the case, why weren't we told that from the first meeting?
You should have talked to your lawyer.
No. Why didn't you tell us?
Lawyer.
No. Please listen to me, please, Mr. Chairman. Please address the chairman. Don't address me, please. Mr. Chairman, the point is, if we didn't have any legal point of view on applying for this, day one you could have said, since you don't own the land, you cannot apply. No one told us that. But the procedure went through. Because the gentleman saying, if we didn't, since you grant something for someone who owns it, but you did not tell us.
Mr. Chairman, at the time, could I make an observation? At the time of the application in January, we were not aware, or I certainly wasn't, that the land was in 61A. I wasn't aware of that. I had no personal knowledge of that.
I thought it was a
And
farm
answer your
covenant.
question, I am not a lawyer either, so.
Yeah, Mr. Chairman, that's not the point. The point is, I'm commenting on his point that since we don't own the land, we have no right to apply. Everyone applies, then they don't own the land, number one. Number two, if that was the case, from day one you told us, go get the land, and then come and apply to us. And no one told us that. Thank you, Mr. Chairman.
But apparently, Mr. Brackett talked to your attorney, and your attorney knew about it, and he was denying it.
No, but this is the 61A issue. I'm only addressing the gentleman's point of view that you only listen, the board, the ZBA, only listen to people who have the land in their possession.
Or have a right to buy it.
And we have the right to buy it.
Not subject to a cloud on the title.
Well, I don't know what's the cloud. The cloud, anyone can come and cause a cloud. Mr. Chairman, anyone can come and cause a cloud about it. The zoning board job is to basically vote on it, and if there's a cloud, the cloud will be cleared or not cleared. That's a separate issue.
Yes.
Thank you, Mr. Chairman.
Mr. Chairman, just briefly, clearly I don't know when the purchase and sale agreement was negotiated on this property and whether or not the applicant had legal counsel at that time, but the obvious question for any party purchasing land is, the classic slogan of buyer beware. And the fact that it was in agricultural use or had been in agricultural use was certainly not a hidden factor for this 55 acres of property. So the the Islamic Society and their attorney were under the same obligation to inquire about that as the owner and her attorney was to provide the proper notice, because she had been clearly receiving the tax benefits on the property for a number of years. So I have reached out to the attorney for the Islamic Society. He doesn't agree with my interpretation. I've advised him that, and interestingly enough, he posted this question on a listserv for city solicitors and town council across the state. And the majority of the responses came back in supporting our position, that if the intention of the statute is to preserve agricultural land, once you change it from agricultural land to non-agricultural land, and there's an SJC decision on record and an appeals court decision that my partner Elaine Lucas handled that speak to that issue, a change from agricultural to non-agricultural land, which is clearly the case here. It's a conversion, and therefore the notice is required. So I wouldn't agree with the statement that this board or the planning board, when they give out zoning relief, are giving permits to people who don't have a property interest in the land in question. You either have to be an owner or a contingent owner or a tenant of the property in order to qualify to proceed for zoning relief.
So well, I think, we've been meeting for several months with these people, looking for something from them to bargain with us, to reduce the amount, to work with us. We haven't got that. So I didn't bring any of the stuff I had tonight because I wasn't going to vote for attaching conditions. So I didn't bring any of the stuff I had prepared for conditions.
Mr. Chairman, I'd be interested in listening to Council's draft of a motion that he's indicated he prepared relative to standing.
Mr. Brackett, can you please pass out the information?
Mr. Chairman.
We didn't hear the question, Mr. Chairman.
I would be interested in hearing Mr. Brackett's draft of a motion relative to standing, the standing issue.
John, it's right there.
Did you?
Would you like to read it?
You fellas.
Mr. Chairman.
Go right through.
I have a question. We've been meeting on this now,
That's it.
like Roger said, for almost 7 months. And we have some time restrictions as far as responding in a timely manner, whether it's 60 or 90 days, whatever. Where are we with that time frame?
July 2nd.
July 2nd. Okay, thank you.
Mr. Chairman, just for Mr. Canty's information, at the last meeting, we raised the question with the applicant as to whether they were willing to extend the time frame to allow the board to consider this revised proposal that was reported on May 20th. And the applicant advised at the last meeting that they were not willing to extend the time frame.
Mr. Chairman.
Mr. Brackett. Question. If, for whatever reason, town gets first right of refusal and it goes to town meeting and then it goes to town election for a debt exclusion, debt exclusion is not approved, the property goes back on the market,
would the Islamic Society have the right to approach and renegotiate an offer to buy their property at that time? And
Yes, they
we
could
start
certainly,
all over again?
they could approach the owner and negotiate acquiring whatever acreage, either all the entire 55 acres or whatever acreage they need.
Would they have to go through the process again? Would we have to sit here for 2 months and go through this process again? Or if they reacquire the land, we could go with what we've already heard for over 2 months?
Well, if they reacquire the land, the question would be whether or not they're presenting the same proposal to you for the same parcel.
And say they are.
I think you could certainly have a streamlined hearing at that point. The question would be whether or not you would incorporate testimony that you've received from the previous hearings. You would still have to have public hearings and notice to the abutters as required. But I think you could take notice of what you have in the record, and we'd have a listing of all those documents that would be basically incorporated in the record.
Gary, we have to make a decision, one way or another, on this thing tonight, because we're running out of time. If the town votes to buy this land, then the decision we made is a moot point, because the town's going to own the land. So denying it isn't going to make any difference one way or the other, right? I mean, it has no bearing on what the town wants to do.
Well, the denial is, as I mentioned earlier, if the denial is just on the procedural question involving standing
Yeah.
for the
Yeah.
applicant,
Yeah.
and it's not a denial on the merits of the
No,
application,
it'd be,
then they could come back and resubmit if the town meeting and ballot question process doesn't result in the town owning the land.
okay, and this is all the motion, right?
Yes, I have, if we need to amend it in any fashion.
Well, would you want to insert language that says that in the event the town does not acquire the property, the Islamic Society entered a new purchase and sale agreement with the seller, then we'd be more than happy to hear their request for a special permit.
Well, I think we would anyway.
Well, I mean, do we want to insert that in here so it's on the record that they're not, the
Well, yeah,
special
okay.
permit is not being denied? What's being denied is their ability to seek one
Mm-hmm.
at this juncture.
Yeah,
I don't have a problem with that, John, but if the town doesn't buy it and it goes to them, I don't want to sit here and listen to the same old stuff again. I'd rather have us make a decision. So, they can present it to us again,
Yeah.
and then, no open thing, just do what we gotta do. Is that possible?
Well, I
I
think,
just,
No,
I think
you-
they would be coming back with a different plan. It's my understanding.
why would that happen? They're not changing their plan. They said they're not changing their plan, not changing the time
Actually,
frame.
the gentleman just said that
Yeah.
they were going to make it smaller to 5 acres.
See?
Okay.
So presumably, they would come back with a plan setting forth something much more modest, in keeping with what they're promising, that they would just want a smaller parcel. But I think we should probably incorporate in here, so that, for the record,
they won't be held to the 2 years, is that what you,
what I want it to be clear to the public that they have not been denied a special permit for acquiring a cemetery. They've been denied the ability to seek one because they don't have standing. And that if the town does not buy the property, they have the absolute right to come back as a contingent purchaser to seek a special permit. That's all. I want that in the record because there's been so much abuse of this process to the public that the only reason that this would be denied is because they don't have standing, and that they have the absolute right to come back under the right circumstances, which would be if the town did not buy the property. And I want that in the record.
I'd be all right with that.
Hey,
Fine with that.
Are you all right with that?
So somehow we could-
There is one thing I would like, as a matter of policy for this board, to be established going forward, when we hand out applications, et cetera, that something regarding 61A be factored into the application permit, so we don't get to this point and we're doing this.
Yep.
That's fine.
Okay?
Agree.
Yep. How do you feel about that, John?
Yeah, well, I'm fine with the fact of the grounds that we're standing on. It's, if the town for some reason doesn't buy it, you know, I feel going through this process and having the hostility, either both ends, going through all this is not good. You know, I'd like to streamline that, kind of like Gary said, and make a decision. We have to move forward, you know? But as far as the grounds that John's stating, I totally agree with that. To your point, not knowing about the 61A, we didn't have the proper information, shame on us, but we need to get that information ahead of time.
Public hearing is closed, but if you,
No problem, I'm sorry.
I mean, if you have a question for Mr. Brackett,
Yes, I have a question for him, actually.
I will allow it.
You mentioned that 3 parties only can apply: owners, potential owners, and tenants. In your definition, you don't think that we are potential owners?
Mr. Chairman, a person with having a conditional purchase and sale agreement could be someone who is a potential owner.
Right.
But in this case, your proposal to acquire the property is secondary to the town's right of first refusal. And until that right is exercised or not exercised, you don't have any legal rights to
Right, but
proceed.
that's a separate issue from the board.
No.
This board has separate issue for that. We are potential owner, and whether we did, let's say that there was, let's say that there was a lien on the property. If there was a lien on the property, then
It's just a
the board
question
can
to the
say
lawyer,
there is no
that's all.
lien on the property.
You make
that
the
we're not
motion,
gonna,
because you
approve
want to
it because
add
there is
to
lien
it.
on the
Oh, okay.
property.
Okay?
Okay.
So we are potential owner, and all what we're asking the board to vote on our proposal. Thank you.
We got to write it in there.
Mr. Chairman, question for Mr. Brackett.
No.
So we want to get something.
Richard Raymond, I'm in the butter. The question, the applicant had a
Brackett.
chance, and so I'd like to ask a question to Mr. Brackett. If I'm hearing this correctly, the mere fact that the applicant would not have standing, okay, just negates the application. It doesn't, so if the town doesn't proceed, if the town gets proper notification from the seller, and the town elects not to make the purchase after going through all the process, that land becomes free and clear for anybody to purchase, am I correct?
Well, yes, yeah.
Yeah,
clearly
whether it's that applicant or another one.
It could be purchased by anyone, and
Exactly.
someone could seek
Okay, I just wanted
zoning
to,
relief at that time.
thank you.
Now, if it does not get approved, then
It'll go. I mean, this motion? This motion?
Mr. Brackett, under 61A, does the town, in any land under 61A, does the town have the right of refusal on all that property? Anything that falls under 61A?
Yes, the town, whether it's, if the owner is going to convert the property
Yeah.
to a non-agricultural use or sell the property for non-agricultural use, the town has the right of first refusal.
Okay. Thank you.
Okay, so, I would make a motion that we issue an order denying the permit, denying the applicant's request for a permit for lack of standing, as written here, and at the end, just insert the following: in the event the town elects not to exercise the right of first refusal to purchase the property, and the society enters into a new purchase and sale agreement with the seller, the society is more than welcome to submit a request for a special permit to use the property as a cemetery.
Second.
Okay, a motion's been made and seconded. All those in favor?
Aye.
Aye. Opposed? Motion carries.
Mr. Chairman, we're all done. I'll make a motion to adjourn.
Wait. Did you actually vote on the motion, the main motion, or did you just simply vote to include that language, and is there a second vote needed on the entire motion, and should it be read?
Mr. Brackett?
Motion has.
I agree with Mr. Belkonis. I think the safest course is probably to vote first on the amendment.
Okay.
And vote on the motion as amended.
Okay.
So you made a motion for the amendment,
Right.
and you seconded it. All those in favor?
Aye.
So we amended the motion to
Okay.
read as follows.
Okay,
I make a motion
that,
that
John
we,
gets to read it.
oh, okay,
I gotta read the whole thing?
yeah, you go ahead.
Oh, God. I move that the zoning board of appeals vote to deny the applications for a special permit for the property on Coburn Road for the reason the Islamic Society of Greater Worcester is not eligible for the applicant for such permit for the following reasons. The land in question compromises approximately 55 acres, is currently taxed at agricultural and land pursuit to MGL C 61A, pursuit to MGLC 61A, and 14 land tax under the chapter shall not be sold for or converted to non-agricultural use while sold, taxes or within 1 year after the time unless the town of Dudley has been notified of the intent to sell for or convert to that other use. Any notice of intent to sell non-agricultural use shall be accompanied by the following: a statement of intent to sell, a statement of proposal use of land, the location and acreage of the land, the name, address, and telephone number of the landowner, a certified copy, an executed purchase and sale agreement, specifically the purchase price and all the terms and conditions of the proposed sale for which shall be bona fide offer as defined by Section 14. The notice of intent to sell shall be sent by the landowner by certified mail or hand delivery to the Board of Selectmen, Board of Assessors, Planning Board, Conservation Commission, and the State Forester. That, to the date, no notice of intent has been presented by the landowner to the use of Board of Selectmen as required. You serious? I gotta read this whole thing? That on May 16, 2016, Town Administrator notified the landowner, Meninsky, by letter of her responsibility to provide a notice of her intent to sell the property to the Board of Selectmen. That on May 23, 2016, the Dudley Annual Town Meeting authorized the Board of Selectmen to execute its right of first refusal to acquire the land pursuant to MGLC 61A 14, and also to authorize the Selectmen to acquire the property by purchase, gift, and element domain. That on May 24th, 2016, the Town Council notified the applicant council that the landowner was required to provide the notice of intent to sell the property to the Board of Selectmen. That on June 6, 2016, the town council spoke by phone with the landowner and advised her of her responsibility to provide notice to the selectmen, and that Ms. Manowski advised that it was her intent to have the attorney, Thomas Barroso, provide the required notice upon return from vacation or about June 13, 2016. That on June 6, 2016, town council notified counsel for the applicant of his communication with the landowner and the fact that the notice of intent to sell was expected to be submitted to the Board of Selectmen by the attorney, Barroso, on or about June 13, 2016. The pursuit to C-61A-14, the Board of Selectmen will have a period of 120 days following the receipt of the notice of intent, which complies with Section 14 to execute its right of first refusal to meet a bona fide offer to purchase the land. Section 14 provides that there shall be no sale of land under 61A to a non-agricultural use unless the town has been given notice of intent of sale and 120 days has passed without an exercise of the town option to purchase, or the town notifies the owner within that period that it will not exercise its option. I have to read the case study.
Yes.
Is that good? Whereabouts landowner Albert Mossy has not complied with the notice of intent required of MGL 61A-14, and the town of Dudley has the right of specific performance to enforce the land's responsibility to Islamic Society of Greater Worcester as the applicant under a purchase and sales agreement has an interest in the property which is submitted to the town of Dudley and therefore is not eligible applicant at this time for the zoning relief in the nature of a special permit.
Then you're gonna
I've
add,
done that.
and then this is the, then you have to add this.
Yep. Would you like to read that?
Okay, in the event the town elects not to exercise the right of first refusal to purchase the property, and the society enters into a new purchase and sale agreement with the seller, the society is more than welcome to submit a request for a special permit to use the property as a cemetery. So that's the motion.
Okay. We have a motion that's been made and seconded. All those in favor?
Aye.
Opposed? Motion carries.
Mr. Chairman, I would ask that we ask town council to take the information here that applies to section 61A and provide the zoning board of appeals and the planning board with a document of instructions so that people apply in the future, we can have some references to how they have to go about applying properly for that. Okay? Legal and by the numbers.
That's it? We all set? I make a motion, we adjourn?
Second.
Motion's been made to adjourn. Seconded. All those in favor?
Aye.
All right.
Motion carries.